Okay, this is the May 20th, 2015 continuation hearing, Lucas County Zoning Board of Appeals review of Lucas County zoning case issue 714, Pleasant Ridge Energy LLC, Pleasant Ridge Wind Energy Project. Roll calls: Michael Cornell. Here. John Ditson. Here. Richard Kiefer. Diana Iverson. Here. Howard Zimmerman. Joan Usman. Here. And Gibbs Nielsen.
All right, I'd like to thank everybody for their patience as we kind of are getting underway a little bit late. We understand it happens to all. So we will, first order of business, I believe we have from Patrick Engineering, we have Mr. Alan Hymans here. He's going to go over the Patrick Engineering report. This report has been commissioned by the county that have prepared kind of as another set of eyes to look at this particular project. So with that, Mr. Hymans, if you can come forward and be sworn in. Mr. Hymans, right up here. If you please raise your right hand. You solemnly swear the testimony you shall give in this case now and here shall be the truth, the whole truth, and nothing but the truth, so help you God? All right. You're going to have to speak up and into the microphone a little bit better. All right. Is it better?
Not much. Got to turn it.
All right. We're going to work through a series of questions, and the audience may have some questions as we get through this. Is there anything you might preface these reports with, just kind of give us a background on any of this, or you're going to go through? Okay. All right. Mr. Griffin's going to have some questions for you.
Mr. Hymans, my name is Jim Griffin. I'm an attorney, private attorney, hired by the Livingston County Board. Where are you employed at?
Patrick Engineering out of Springfield.
And what type of firm is Patrick Engineering?
Patrick is basically a full-service consulting engineering firm, and we also do design build.
And what is your education background?
I am a graduate electrical engineer from the University of Maryland, and I am a licensed professional engineer in the state of Illinois.
And how long have you been a licensed professional engineer?
About 40 years.
And what is your position as Patrick Engineering?
I am a senior engineer.
Right. Now, Patrick Engineering was retained by Livingston County to perform some analysis relating to the Pleasant Ridge wind farm. Is that correct?
Yes.
And what did the county ask Patrick Engineering to do?
The county asked us to review Invenergy's permit application with respect to the county wind ordinance, and to provide a checklist that the applicant's information met all of the reference and provided materials concerning all the elements of the ordinance.
And we asked, was Patrick asked to do something concerning the decommissioning of the ordinance?
Yes, we were asked in our review, we made a comment that the county should look at an independent decommissioning study to verify the costs in the decommissioning report. So we issued the decommissioning report request.
And what about noise? What did you do?
As part of our work, we were asked to spot check the developer's noise study and to basically validate that their results were representative of what might be said.
And what was your personal role in the work that Patrick Engineering performed for the county?
Overall, I was the project manager for Patrick, and under my direction, it was my responsibility to see to it that the report that the county requested was complete. I also performed the spot
Now, Mr. Hyman, the reports prepared by Patrick have already been placed into the record as Livingston County Exhibit 13 and Livingston County Exhibit 14. Are those the reports that your firm prepared on behalf of the county?
Yes, they are.
And do those reports provide the analysis that Patrick Engineering performed in this case?
Yes, they do.
As to the noise analysis, can you briefly describe what was the result of Patrick Engineering's work?
We spot checked 3 different locations at the request of the county. The locations were chosen by us or by the county. What we did in that spot check was we picked a receptor location that was surrounded by turbines within a 2,000 meter radius and determined the noise levels at the receptor. And we found that with all of the parameters that we used and the methodology that we used, that none of the locations that we spot checked were in variance to the IPCD requirements. And based on that, we felt that spot checking any of the other locations would validate the study that Invenergy provided.
As to the decommissioning analysis you did, what was the result?
On the decommissioning analysis, we felt that the bottom line was that the costs presented were not, were a little bit lower than we had calculated. The Stantec report indicated that the cost per turbine to decommission would be around $37,000 ultimately, and our analysis indicated it was more in the range of $63,400. However, we did qualify the results by indicating that the county should reevaluate these costs every 3 to 5 years because costs change, and to provide a more accurate estimate as time progresses.
Thank you, Mr. Hyman. Mr. Chairman, that's all the questions I have.
All right, ZBA, do we have any questions at this time? Mr. Hyman? All right, we'll reserve our opportunity to ask questions. We'll allow the others to possibly ask those questions. Units of local government, school districts, anybody out there representing those entities that may have questions for Mr. Hyman? Mr. Blazer, do you have any questions for Mr. Hyman?
No questions.
All right, Mr. Lukens, do you have any questions for Mr. Hyman?
Yes, sir.
All right.
First of all, let me apologize to the board, the ZBA and the county board, as well as Mr. Blazer and the residents for my tardiness. Mr. Hyman, and one other thing, just so the record is very clear, you and I have never met, correct?
That's correct.
But you may or may not know that I am one of the outside counsels for Patrick Engineering, correct?
That's correct.
And we have not talked about this, nor have I talked to anyone of your staff about this report.
Not to my knowledge.
Mine neither, so we're safe. Let's questions about your reports. Let's start with the compliance part of your report, and it's listed as in our Livingston County Exhibit 13. Your checklist does not indicate whether the permit application is complete, just that something was submitted for a particular item, correct?
That's correct.
A financial commitment letter is required under the ordinance, correct?
I believe that's correct.
Okay, and it's not a memory game, so if you want to go to November 3rd, 2014 letter, I'm really on page 2 of that. Do you have that? I think it's just the second page, Mr. Holmes.
Yep.
Okay. And you would agree that no financial commitment letter, however, is included if you look at what I'll call the first full paragraph after the conclusion section. The third bullet point.
Correct.
It goes on to say in the fourth bullet point in, I don't know, let's start with the last bullet point on the same page. It starts part 2JB, or J2B, excuse me. You would agree with me that a pre-construction baseline survey of existing roads is required by the ordinance, correct?
Yes,
And that has not been done here yet, correct?
that is correct.
Okay. You also note that the ComSearch study and the applicant study do not match as far as microwave path scope, correct?
That's correct.
Okay. Let's go to the decommissioning studies for a couple minutes. And that's Livingston County Exhibit 14. Did you include any costs for crop loss?
There was I'm not sure exactly where in the report, but there was some comment in the report concerning using machinery to go from tower to tower across farmland, but the cost for running across the farmland in terms of crop damage or other methods or means to do that was not costly.
Okay. So that was just not a cost you included?
No,
Okay. And that's, I'm just trying to understand.
that's fine.
How about, were there any I didn't see any costs either for drain tile crushing?
No, sir.
Okay. And one of the things I noticed is you have a 38% efficiency, marked down based on the fact that it won't take as long as, that it can be done in a year instead of, I don't know, it was like 100 and some weeks or something. Do you recall that?
Yes,
Okay. How did you come about that 38% efficiency?
that was derived by by saying that if the farm could be decommissioned in 52 weeks as opposed to 1 week per turbine or 136 weeks, that there would be a level of efficiency that would come out of that, and that efficiency number was determined by our staff to be 52 divided by 136.
Okay. So it was based strictly on a,
Strictly on a time
okay.
basis.
You would agree with me that no matter how many weeks it's done under, the labor still has to all go out. I mean, you can't do 52 weeks of, or you can't do 136 turbines in 52 weeks as far as strictly labor costs. And I'm talking just labor costs. Any cheaper than you could over 130 weeks or whatever your number is.
I can't answer that.
Okay. One thing I think we would both agree that would be reduced is overhead profit by shortening overhead profit, especially general conditions, would be reduced by shortening the time frame,
I
correct?
would say yes.
Okay. And in your experience, general conditions are somewhere in the range of 5, 10, 15% of the job, correct?
Over that range.
Yeah, somewhere, depends on the job, depends on, but it's not, most,
I believe the report used, I believe it was 2 or 3%.
okay, for general condition, or, okay. And then overhead profit was another 5, 10% at that.
That I don't recall that number.
But that would not be an unreasonable number, correct?
I would think not.
Okay. Do you know what percentage of the costs are labor rates in your
I
study?
do not.
Okay, do you know what labor rate was used?
I do not.
Did you assume a union contractor or did?
I couldn't tell you. I don't.
Okay. Did you call any contractors, whether they be local or wind farm contractors, to determine what they would charge for this kind of project?
I know that they did call some salvage yards.
Yeah.
And the other information as far as costing for contractor labor and work came from internal project experience and recent project costs for contract labor.
And so that would have been the same thing for trucking and manpower?
Yes, sir.
I see you used a 30-year average on salvage costs for steel and copper, correct?
That's correct.
I looked at the charts that were referred to in the, we may talk about them in a minute, but I looked at those charts, and I guess my conclusion, tell me if I'm wrong, is that the prices go up and down, but you're just using the average because it kind of stays the same throughout a 30-year period.
Yes.
On the other hand, union costs for operators, local 150 members, those have gone up every year, or maybe not every year, but regularly for the past 30 years, correct?
If you say so.
Okay.
That I don't know.
Okay, you don't know.
I'm
But
not a labor cost specialist, so I can't answer.
have you ever seen labor costs from a union go down?
Again, I have not paid attention to those.
Patrick Engineering is part of the Dietzler companies, correct?
Yes.
And the Dietzler companies also, whether they're still in existence or not, maybe, I'm not sure at this point, but they also own a company called Alvin Carlson, correct?
That's correct.
And Alvin Carlson is a contractor, correct?
That's correct.
And they also own a company called Vector, V-E-G-T-E-R.
As far as I know.
Yeah, and I'm not sure if they're still around or not either. So, but you didn't, to your knowledge, did any of your people in the Springfield office call either the Alvin Carlson people or the Vector people for any cost?
I don't have that knowledge.
Okay. Can you tell us what the costs for what the costs are included in your number for cutting and preparing blades for salvage?
I don't know how these numbers were arrived at. All I know is that our staff that is educated and has the expertise in creating these cost estimates
Okay.
put these numbers together.
So if I asked you about the costs for separating copper from steel or the cost for stripping the wire to become number one copper, you wouldn't be able to tell us how that was resolved. Mr. Hymans, I'm going to show you what I've marked as UCLC Exhibit 201 and 202. I'll give them to you both at once so we don't have to do this twice. Okay. Have you ever seen these charts before?
No, sir.
Okay. I will tell you that these are the charts that if you click on the websites that your report has in them for where you got the copper and salvage, that these are the charts.
Okay.
Can you also, if you look at the top, it says all values are in metric tons. Do you see that?
Okay.
Are these numbers to your knowledge, if you know what scrap is being resold for and not what the salvage yard cost is?
I do not know.
Okay. These are, as I said, they're in metric tons. Isn't it true that Stantec was not setting forth metric tons in its calculation, but English tons?
No, sir. You give me a copy of that here. It would appear that their numbers are in English.
Okay. So let's just talk about, just to make sure we're all clear. A metric ton is 2,200 pounds, correct, per ton? And a English ton is 2,000 pounds per ton, would you agree?
Yeah.
Okay, so it's a 10% difference. So that if it is English tons, as we agree it is, your estimate of scrap value would be 10% high, correct?
Without reviewing further, I can't answer that.
Okay, well, let's assume for the sake of my question that it is. And 10% of the salvage cost would be about $960,000, correct?
Okay.
Okay, another of the assumptions you made in your access road excavation and removal was going to be that only 50% of the access roads were going to be removed. Do you recall that, or are you aware of that?
That's correct.
Stantec, do you recall, assumed that all the access roads would actually be removed?
Yes.
And it appears from looking at your report, you made that assumption because you were asked to by the county?
We were asked to revise our original report from 100% removal to 50%.
Your original report was at 100%?
Yes, sir.
Okay. And we would agree, would we not, that roads take away land from the ability to farm if they're on a farm?
Yes.
So if all the participants wanted to have their access roads removed, the total cost of decommission would go from $8,621,000 to $11,831,000, correct?
I don't know the numbers, but we did qualify our comment and report.
Absolutely. I mean, that's how I found it out. I'm not trying to, you didn't hide it. I'm just trying to make sure. But the access road cost, in your estimate, if you looked at page 13, the decommissioning cost, in the chart, about 2/3 of the way down, it says access road excavation and removal.
Yes.
And that's got a cost, and then again, this is exactly what you did. You said, this is only 50% of the cost. But the 50% of the cost is $3,210,000, correct? Okay. So if I was to double that, and I assume your original assumption was that number was more like $6,400,000.
Okay.
Okay. So if I add $3,210,000 to the $8,600,000, I come up with $11,831,000. Does that sound right?
Okay.
Now, if I add the 960 on the 960,000 for the metric ton versus English ton issue, I get $12,791,000. That's $12,791,000 approximately. Does that sound right?
Okay.
Okay. Thanks. Let's go to the sound study where I know you have a little more information or you were more involved. Let's just say that. And that's Livingston County Event Exhibit 13. Just so we're clear, as you said, you didn't do all the wind turbines, you just picked 3.
Yes.
Or 3 receptors. I apologize. That's it.
In the original report, we only chose 3 locations.
Okay, and then you went back and chose another 3?
Yes.
Let's go to the 3rd page of the May 6th, 2015 correspondence. So I guess that's your last report. It's a chart. It's got yellow and pink on it.
Okay.
Okay. Now, what it appears you did here, and it might say it, and I just forgot exactly how it came about, but it appears you were asked to also look at other calculations regarding with LNTE blades, 100 feet away from the house, etc., correct?
We understood that there was information concerning where the readings should be taken.
Okay.
So what we did was we provided the analysis based on the original assumption that the receptor was located at the residence. And then we provided a comparison to moving that receptor 100 feet away from the residence.
Okay, and just for the record, the turbines, you didn't use, when you looked at a receptor, you didn't look at every turbine in the air. You just looked at 1, 2, 3 closest turbines. You made a decision, a judgment call.
On this analysis that we're talking about here, we looked at the receptors where the turbines were closest to the receptor, and then if there were others that were within a reasonably close distance. And in this case, we went from 1,600 feet to over 3,000 feet and included those turbines in the analysis to that receptor.
Okay, here's what I'm interested in. The only measurement, or the only modeling you did was not with the LNTE blades at 100 feet. You modeled the regular turbine blades at 100 feet, correct? You measured them at the receptor and you measured them at 100 feet closer. Is that what this chart shows me?
And we also did it with the LNTE blades.
Did you do 100 feet with the LNTE blades? Because I don't see that. Where's that?
If you look, number 2A-100L.
Okay, let me just, 2A-100L, okay.
That's with the LNTE blade. The 3A-100L is also with the LNTE blade.
Okay, great.
100 feet.
Okay, so let's walk through that for a second. So you did it twice. You looked at LNTE 100 feet, or you looked at LNTE at the receptor, right?
Yes,
And then you looked at it with the LNTE 100 feet closer.
correct.
Okay. So you did that both, then we'll stay on 2 and 3, just 2A and 3A, okay? So if I looked at 2AL, I would come up with 38.6 decibels at the 1,000 hertz level. I'm going to stay at 1,000 hertz.
That's correct.
Okay. If I measure 100 feet closer to the turbines, I have 39.2, correct?
That's correct.
Okay, so I have a 0.6 more decibels 100 feet closer.
That's correct.
And then if I go to 3A, I actually have the exact same change between 3A with LNTE blades and 3A at 100 with LNTE blades. At 100 feet closer, it's another 0.6, correct?
Correct.
Okay. And that's actually the exact same amount with or without the LNTE blades that you get every time you come 100 feet closer in your chart at 1,000 hertz.
Okay.
I mean, you go in the first one, you go from 37 to 37.6. And
If you look at the numbers,
Yes.
that's the way it comes out.
Okay, thanks. So in each instance, that 100 feet equaled 0.6 decibels higher at the 1,000 hertz level. That's correct.
Yes, for those two locations.
And it actually for all three when you just did turbine when you didn't use the LNTE blades, correct? So let's just walk through it so we're all
Yes,
clear.
that's correct.
Okay, so in 1A we go from 37.0 to 37.6, 2A we go to 40.7 to 41.3, and 3A we go from 39.9 to 40.5.
Okay.
Okay. So those are pretty consistent. As you get 100 feet closer, we add 0.6 decibels according to the model that we did. Okay. Nothing further. Thank you.
Anyone in the audience with questions? Okay, get your name. Yeah, why don't you come on up so everybody can hear you? Just to be certain you're not representing others from the panel there. Okay, all right. Please state your name for us and then you can go ahead.
My name is Al Slagle. I'm 12 Ridge Drive in River. Looking at your engineer's opinion of cost, you're using for your labor rate, $60 an hour. In all the line items where you list labor only without equipment and so forth. So, did you know that in Livingston County, the cost of, say, an operating engineer as of June 1st is $101.83 an hour? You didn't know that? You did research to see what the labor rates were?
As I stated earlier, this report was done by other members of our staff who are experienced.
Did you know?
Speak into the microphone.
I'm sorry. The study was done, these numbers were derived by members of our staff who had expertise in this, and I had to assume that they knew what numbers to use. So the $60, which was $105, I can't speak to.
And to even compound that, the $60, according to your report, also has to include contract with market as well. So I don't know what labor rate was really used, maybe 52 or 55 or something like that. So
I already explained to the attorney that I did not have any input in this. So I can't speak.
So regardless, all the labor of this entire report is just covered by what we have. And is that, do you agree with that?
Mr. Chairman, I'm sorry, I was trying not to object, but.
Right, we need to make sure,
He's not
we
asking.
need to make sure we focus
Okay.
questions.
So I guess my question is then how do you justify the report when you didn't check the labor rates? How do you do that?
I personally did not check the labor rates. The labor rates were done by members of our staff and done in all this.
So did I understand you to say that you were overseeing all them? You were in charge of that?
I was the project manager, and it's my job to see to it that the report is complete and contains all the developments necessary to produce the report, but I am not technically responsible for what's in that report.
So how do you say it's any good?
Because I have to rely on my staff to give me
So you didn't,
accurate results.
so you didn't spot check their work?
Mr. Chairman, again, this has been asked and answered 3 times already. I don't know that it's Mr. Blazer's objection. I have as much of a right to object to this as anybody else does. Mr. Griffin.
If you can continue with questions, but be sure your questions, and he has asked and answered that several times.
Well, I guess that's all we'll ask them. I don't really want to be asked by Mr. Baker.
Anyone else in the audience with questions? Anybody else out there?
Mr. Chairman?
Yeah. Sorry, you're behind me, I don't know, so it's the only way you get my attention. Go ahead.
Carolyn German. When you say that your staff had experience with this, have they had experience with decommissioning wind turbines?
I have been told that, to my knowledge, there have not been any wind turbine farms that have been decommissioned. And so these estimates are strictly that.
So they're strictly theoretical at this point?
I wouldn't say they were theoretical, I would say they are based on engineering expertise for doing work of a similar nature.
Have they decommissioned any 40-story structures in a rural location that were made of steel?
Not to my knowledge.
Or anything like that?
Not to my knowledge.
Okay. Are the staff members professional engineers?
Yes, ma'am.
Okay. And have they, I guess I'm just trying to understand, you know, it's not theoretical, but it's not really based on
Their estimates,
experience.
they're based on experience of decommissioning facilities, but not necessarily 40-foot structures like you're talking about, of steel that I have no knowledge of. But it comes about from other decommissioning projects that they have experience with.
Okay. And I noticed that the numbers were given in 2014 dollars.
That's correct.
So you would, I assume, recommend that we take into account inflation changes?
We did recommend that the report be revised every 3 to 5 years.
I noticed the footnote on the November 3rd, footnote 1 says the accuracy of the setbacks is limited due to the sources of readily available information. Catholic did not perform any field verification.
That's correct.
Okay.
Ma'am, what was your name?
Carolyn Gordon.
Anybody else in the audience with questions? Anybody? ZBA, anybody have questions?
Joe Houston. Mr. Hines, how did you measure at the receptor locations?
Excuse me.
Can you describe for me how you measured at the receptor locations? You chose 3. Where on the receptor locations did you measure from for sound?
The locations were at the wall of the residence closest to the turbine. In the first analysis, the first 3 spot checks that we did, the receptor was at the center of the residence.
And for those receptors, how many turbines impacted that each receptor? Is that in this report?
That's it.
Can you point me to where it's at?
If you look on figure PEI-5, it's toward the end. In fact, it's the very last figure.
I don't mean to interrupt, but I need a little more description because I can't find it. So you can, oh, that thing, okay. Thank you.
Okay.
And on that map, there's 3 circles. And the center of each circle is the receptor that was identified in the study. And the circle has a 2,000-meter radius.
So which side of the residence did you measure from?
On these, it was at the center. The receptor was assumed to be in the center of the circle, which would have been right on the residence location.
Do you think that matches with the Illinois Pollution Control Board's requirements?
The Illinois Pollution Control Board requirements reference noise from a Class C land to a Class A land. And all of these residences, as far as I know, are on farmland. And the only way to interpret that farmland where the residence is located is that the residence itself is Class A land. And so based on that, the standard from what I have observed and from what has been done in the past on other wind farms is that the receptor is located in the center of that residence.
But you initially measured from the external wall.
On the labor reports.
Not on this one. I don't know if
This one.
was the last.
This one here, you asked me how many wind turbines we use to the receptor.
Right.
Within this circle, that's the number of wind turbines to that receptor.
Okay, and then in your initial study, did I understand you correctly that you said you measured at the receptor at the external wall of the Class A property?
I didn't measure at the receptor, we predicted the sound at the receptor.
And you predicted based on the distance to the external wall?
We based it on this study here. We used the turbines that were within the 2,000-meter radius of the receptor.
So these are the 3
And these
additional.
receptors, These receptors, the coordinates of these receptors were taken from the Invenergy study.
Are these the 3 additional receptors or the 3 initial
These are
receptors?
the 3 initial.
These are the 3 initial. I thought I understood you to say in your initial prediction, you predicted to the external wall of the Class A property. I know it seems like it's splitting hairs, but this is what we've been sitting here listening to night after night, and I'm trying to figure out what is correct.
On the initial report, the receptor was located at the coordinates that were provided in the Invenergy study. Okay, I did not, no, let me rephrase it. It was assumed that the receptor was at the center of the residence, okay, where that receptor was located. Okay, so from that point out 2,000 meters, a circle encompassing all those turbines, those were the turbines that were used to predict the noise at that point, at the center of that circle.
Okay. So would you interpret the different land classifications? Like, I'll just use my own property, for example. I have a house on about 7 acres. I have a barn, I have a shed. How would you classify my property? And I have lawn, and I have pasture.
According to the IPCD, agricultural land is Class C. In our interpretation of Class A in an agricultural setting, that included the land that the residence sits on. Okay? That was as far as I went with it. And all of the studies that I had seen for wind farms had used the residence as the receptor location, not the yard, not the lawn, or anything else. And I understand that there's been quite a bit of discussion concerning that. And that's why recall his first name. That's why he was asking about the 100-foot out from the residence. That was to try to take into account some of the discussion, so we could show what the difference was between measurement at the receptor, at the residence versus 100 feet out from the residence.
Okay. With other wind farms or wind turbines, have you gone back, has Patrick Engineering gone back and measured actual sound measurements or noise
No, we
measurements?
have not taken noise measurements in the field.
So we don't have any actual measurements to
These
base
measurements,
decisions off of?
these numbers that we presented are predictions that come from the prediction models. You probably heard the ISO 9613. That was the algorithms and the software that we used. That was the same that was used in the Invenergy study.
Okay. Nothing further right now?
Mr. Hines, I have a few questions for you. As you initially were commissioned, I guess, to do this report, how did you determine, you said you did spot checks, how did you determine what location to select?
We selected 3 locations, one in the western area of the project, one in the eastern area, one in the southern area. And then we looked also for receptors that would have the maximum number of turbines within that 2,000 meter radius that would impart sound
Okay, all right. So, as I look through your November 3rd letter that you had sent to us, on page 7, and you said earlier, you said that none of the, everything seemed to, we'll say, jive with what Invenergy had provided. But yet, I read in here, location R59 exceeded the regulations by 0.1 dB, while location R240 exceeded by 1 dB.
Right.
Okay, so
If you want an explanation, those readings were based on adding in worst case ambient noise. When you did not add in the ambient noise, if you just used what the IPCD regulation requires, which is the noise emitted from the source to the receptor, none of the locations exceeded the IPCD regulations. It was only after we added in, just to give you an idea of how much extra noise basically was necessary to get beyond the IPCD regulation. In other words, there's two different levels that you can use. There's a rural noise ambient, and under the rural noise ambient, none of the sites exceeded the IPCD regulation. The one that we used that did exceed, and we showed both examples. The commercial business ambient noise, which I think you'll find very difficult to find in the areas where this wind farm is going to be placed. That would be an absolute worst case. And that's what I did. I did that to show that if this was in downtown Pontiac or downtown Bloomington, and you were putting this wind farm in, you would have business commercial. But out in the rural areas where the wind farm is actually going, you have the rural traffic of concern ambient. And under those conditions, there were no areas that exceeded the IPCD regulation. So again, I got to emphasize again, the regulation does not require the addition of these noise levels. The regulation only states that it's the sound emitted from the machinery or factory or composite to the receiving land. It does not say anything about any.
So could the wind turbine itself generate the worst case scenario?
In the prediction model, we used all what we consider to be the worst case conditions for the wind turbine. The ambient has another level, but the ambient is there whether you have a wind turbine or not.
But without the wind turbine, it doesn't bother you. It's not 24/7.
Okay. On the decommissioning, just so I can look at this table, I'm sorry I'm skipping around, but 13, table 13. So your estimate is this 18,559,000?
Yes.
And
Yes.
and the submitted plan, Invenergy's plan is this previous column, is that
The 19,890.
okay? And the discrepancy ends up in the actual value of salvage. Is that moreover that's the bigger how your plan and their plan actually has a discrepancy?
appear from the table that some of the demolition costs, I don't know that those are salvage costs.
Okay. Your initial statement, though, was that Patrick has determined that it would cost more than they, or did I mishear that?
Yeah, no, the actual cost per turbine,
Yes.
we determined was not quite twice what the Invenergy study. In other words, the ultimate cost per turbine to the county was going to be, I believe it was 38 something, or 37.6 or whatever from Invenergy. And our study indicated 63.8, I believe, something in that neighborhood.
Okay.
That was the actual cost to the county.
Let me just, well, that's the revenue side.
The major difference is in the revenue,
Okay.
if that's what you're getting at.
Yeah, I'm just trying to figure out where you actually break that, show me the revenue,
The Invenergy indicated about 14 million in revenue, and I believe we indicated about 8.6
looks like 9.9.
or 9.9. And the difference there was that Invenergy had indicated, number one, that there was some salvage value in the aggregate, and it was determined by calls to aggregate locations, aggregate sellers, that they might accept used aggregate, but they don't pay for it. There's no value to them for it. That was one of the items. And the other, I believe, was in the salvage cost, or the salvage value of the copper and steel.
Okay. Nowhere in this report does it have a single number of your conclusion, does it?
Page 10.
Well, that's I mean, just a single number total cost to the county.
Page 10, 6.0, is that what you're looking for?
10.6.0.
Yeah, on 10 last sentence.
Okay, very good, okay. All right. ZBA, do we have any other questions? Mr. Hines? Sure. All right, Mr. Hines, thank you. All right, I've got about 8 o'clock. Why don't we take a 10-minute break? Actually, I've got 7:58. So we'll get going again at 8:08. Probably when we get back, we can start some closing statements. We've got a few exhibits that we need to take care of as well. To clarify an issue that was presented in the Schlegel surrebuttal testimony, where some numeric values had changed on the decibel emission at 1,000 hertz. For those that don't have the information available, I have reviewed it, and it does in fact concur with the results that were provided. So that is Pleasant Ridge Exhibit 16C if anyone is interested in looking at that further. All right, Mr. Blake, and I believe we have some other exhibits that we need to take into evidence or accept.
Okay, first thing we need to do is some clarification. We have two Pleasant Ridge Exhibit 334s, both of which have been admitted into evidence. The first one Kerber, K-E-R-B-E-R. And the second is a sleep disruption due to hospital noises more recently. And so the first one that was admitted, 334, sleep disruption due to hospital noises will become exhibit 334A. Any questions about that?
Not to, who's that under?
Robert's Republic.
Thank you.
I'll issue a new list tomorrow.
County will accept Pleasant Ridge Exhibit 11B as a neighbor agreement from Pleasant Ridge Energy. County will accept Pleasant Ridge Exhibit 11C as a property value guarantee agreement. County will accept Pleasant Ridge Exhibit 335 as the economic benefits agreement. County will accept Slagle Exhibit 9, anchor, SIR rebuttal, all one exhibit, several page document. County will accept Slagle Exhibit 10A as my calculations versus original Pleasant Ridge application. County will accept Slagle Exhibit 10B as my calculations versus Pleasant Ridge Exhibit 16B. County will accept Steininger Exhibit number 2 as assessed valuation study response dated May 12, 2015. The county will accept Steininger Exhibit number 5 as Exhibit number 3 as the tax computation report, Livingston County, several properties within. All right. The county will accept Hayes Exhibit number 8 with the exception that those portions of Exhibit 8 referring to Hayes Exhibits 9 and 11, which were not admitted into evidence. So we will exclude those particular portions that refer to Exhibit 9 and 11. The county does not accept Hayes 9. We have excluded it, best practices guidelines for assessing sound emissions from proposed wind farms. The county will accept Hayes Exhibit 10 as excerpt from California Ridge Wind Energy Project Sound Analysis Report. The county does not accept Hayes 11, wind turbines can be hazardous to human health. The county accepts UCLC Exhibit 189 as a listing document for parcel MLS number 105706. County accepts UCLC Exhibit 195 as the land-based classification standards. County will accept UCLC Exhibit 201 as copper statistics from the United States Geological Survey. County will accept UCLC Exhibit 202 as iron and steel scrap statistics, U.S. Geological Survey. Accept county exhibits number 12 as the Belle Prairie Drainage District Commissioner's correspondence to the Livingston County government in reply to the Invenergy Exhibit 125. The county will accept County Exhibit 13 as Patrick Engineering Report on the Pleasant Ridge Wind Energy Project Summary Review Report. The county will accept County Exhibit 14, Patrick Engineering Review of Decommissioning Costs for the Pleasant Ridge Wind Energy Project. All right, after 33 meetings, we're ready to begin closing statements. Mr. Blazer, take it away. Just to be sure, Mr. Blazer, we've allocated you a lot of minutes. Can you give us a summary of how you intend to allocate your minutes?
I'm guessing, and you know my guess is never going anywhere near close, but I'm going to try 45 minutes to an hour for the first part, and then probably 15 minutes or so on the tail end.
All right. Let the record indicate 8:17.
And I was going to ask if you want to have 5 or 6 more hearings. Well, before I start, I think it's essential that I say something, and of all the things Phil and I have disagreed about, I think he and I can agree about this one. You people have done an incredible job. And I don't mean just the ones in the front row, but all the ones in the back row that have attended virtually all these hearings. I can tell you, in 33 years of practicing law, I've never been involved in anything this long, this arduous, this time-consuming, this frustrating, and particularly with you, Mr. Chairman. I haven't always agreed with your positions, but I was convinced very early on that you were trying to do the best you possibly could, and nobody can ask for more than that. So, before I launch into trying to remind you of everything that's happened in the last 7 months, good luck. I just want to say thank you to all of you for the attention. Somebody said, I think it was Mrs. Ambrose said, Phil and I get paid for being here. You get your per diem, and that's about it. So I'll stay. Thank you. All right. I'm going to try and very quickly first go through your ordinance before I go through what I think this last 7 months was really about. And I think I can go through your ordinance quickly because I believe Patrick Engineering has handled the lion's share of that for us in one report. So I'm actually just going to go through a few of the items where they indicate that some information may be missing or may not be accurately presented. And I'll start with one that my friend Phil and I do have to announce just on a personal level. His son and my son just graduated from Notre Dame. I was going to play the Notre Dame fight song for you, but it's probably inappropriate. So kudos to the Luke Hansen boys. Anyway, financial assurance. That's one of the things that's raised as an issue in the Patrick report. Your ordinance, it's section 616B6, says financial assurance shall be provided that the project can be developed as proposed. Financial assurance is defined in your ordinance. And the definition is not, contrary to what Mr. United said in his report, a commitment letter. Financial assurance is defined as financial assurance from a credit-worthy party. And then it has some examples. They're not exclusive examples, they're just examples. And the form of evidence of financial assurance that you have received has really been in 2 ways. Number one, the co-bank letter that's part of the application, which is one of the historic lenders that Invenergy has used. But I think far more important is the testimony that was provided to you by Kevin Parsons quite some time ago, where he described for you the financial makeup of Invenergy. $8 billion in installed assets. $2.8 billion of that is equity. That's effectively what the company is worth. hundreds of millions of dollars in equity just in Illinois. And he gave you as an example how the California Ridge project, which was the last major one, 134 turbines in Vermilion and Champaign counties, how that one was developed, the 9-figure equity in that project. So I cannot think of financial assurance from a credit-worthy party, as your ordinance defines, that could be more adequate than what you have received from this credit-worthy party, Invenergy. Number two, and I actually just wrote these because I hadn't planned on talking about these. Phil mentioned the pre-construction baseline survey. That's actually first of all, I highlight the words pre-construction. It's not a special use permit requirement. It's a requirement prior to construction. And it's something that's done per your ordinance in the context of the assumption that road agreements will be negotiated with the appropriate road authorities. And that is in fact happening, as Robert Lenz, the attorney for the road commissioners, testified some time ago. He gave you a report on the status of those negotiations, and they are ongoing. And of course, that will include, because it has to, a pre-construction road survey, because that's the baseline for a road agreement. All right. Let's look at a few of the other Patrick engineering things, and then, like I said, I'm going to move on to what I think this 7 months was really about. Patrick mentions compliance certificates will be provided at a later date. Those are the certificates of design compliance. And again, they looked at the application. They didn't necessarily normally expect them to look through the entire record as proceeding. We did, in fact, provide both certificates of design compliance, both for the GE 100 turbine and the GE 103 turbine. And those are exhibits, Pleasant Ridge exhibits 130A and 130C. Another one, provide copies of project summary and site plan to applicable microwave transmission providers and local emergency service providers. And we actually did provide packages. Those are, that's Pleasant Ridge Exhibit 19, which are the transmittal letters along with the project description and the draft emergency response plan to all of the first responders, including OSF Life Flight in Peoria. And then Pleasant Ridge Exhibit 20 are the few responses that we received, including from OSF Life Flight. And I mentioned in particular OSF because there was some allegation some time ago that there's some concern that helicopter ambulance services don't come into wind farms. And clearly, based on the response that we had, that's not true. OSF didn't express any concerns whatsoever. You can see that letter as one of the documents in our Exhibit 20. The other one, the next one from Patrick, does not address, this is in connection with any potentially hazardous materials like oils and lubricants and things like that. Most of that is actually not in a specific document. It's Pleasant Ridge Exhibit 26. This again seems like 1,000 years ago because it was in November. But that was Jacob Baker's presentation, where he talked about all of the fluids that are actually used, most of which actually are not hazardous, they're biodegradable. But that's all in that presentation. Wetland delineation has not been performed. Some access roads may fall within regulated floodplains. That's not directly a county ordinance requirement, other than the fact that the ordinance requires that we comply with state and federal law. And that's clearly a federal law issue of the Clean Water Act. A lot of that is actually covered in the Livingston County Soil and Water Conservation District's Natural Resource Inventory Report, which is in the record. They discussed that at length. But beyond that, this project will be subject to what are called nationwide permits that are issued by the Army Corps of Engineers. And those permits include permits dealing with the development and construction of alternative energy facilities. And again, if we are fortunate enough to receive approval, clearly that is an appropriate condition that we comply with all state and federal permitting requirements. It's already part of the ordinance, and obviously, we can't build this if we don't comply with those requirements. Next one was a phase 1 archaeological study has not been completed. We did submit what's called a desktop review. Again, that's a state requirement. The Illinois Historic Preservation Agency we will, of course, comply with state law. We're required to. And again, I would assume that that would be a condition of any approval, if an approval is granted. The next one is an IDNR EchoCat report. That's ECO, capital CAT. Has not been completed, which would identify potential threatened and endangered species and nearby natural areas. Actually, that was completed, and it's referenced in the consultation letter from the Illinois Department of Natural Resources, which is Pleasant Ridge Exhibit 110, and then our response to that letter is Pleasant Ridge Exhibit 111. And that's pretty much all that Patrick has to say about some loose ends that may be out there. So now let's turn to what I believe took up most of the last 7 months. And it really boils down to 2 things: fear and intimidation. I've met some wonderful people during this process. I have a note here to myself. It's probably going to embarrass them, but I said to myself here, mention Tom and Linda Ambrose. And I'm mentioning them because they're wonderful people. We've talked at length, we've talked about our backgrounds, we've talked about religion. We actually happened to eat at the same place tonight for dinner. They are 2 of the dozens of very good people that I've met in this county. And dozens of people who are afraid. Where does that fear come from? Some folks would probably say, probably Phil included. I hope you don't mind me calling you Phil. I have a hard time calling you Mr. Lucas at this point. Some folks would probably say that it comes from the fact that we want to put a wind farm here. And if it goes away, so does the fear. And in a way, that's probably true. That's a typical response. And if that sort of response were taken to its logical extreme, I think we'd all still be huddled in caves surrounded by open fires. There would be no cars, there would be no electric lights, there would be no phones, there would be no cameras. Anyway, remember what Dr. Roberts said. I put the word in my notes here, remember, like I expect you to remember 4,000 pages of transcript. What Dr. Roberts said about people's fears when the telephone came out back in the 1800s. Now, there have been noise concerns as long as there's been written documentation. Believe it or not, there were health concerns about telephones. My only health concern about the telephone is the amount it costs me to pay for my kids' phones. There's a thing called telephone tinnitus, Dr. Roberts said. Telephone ringing in your ear. Not the ringing of the phone, but the fact that it would cause ringing of the ears. There's also things about cars, the unheard sounds of cars. So it's not new to have health concerns about noise. And this will sound a little too poetic, but I think it makes sense. The road of human progress is pockmarked with fears of the new and the unknown and what we're not used to. But there's nothing new about a wind farm in this country, or in this state, or in this county. And just look at what one of UCLC's own documents points out. It's UCLC Exhibit 42, U.S. Department of Energy's wind program, lasting impressions. By August 2012, the U.S. wind industry totaled more than 50,000 megawatts installed power capacity. Wind power is expanding across the United States and is deployed in 31 states and territories. Texas alone has more installed wind power than all but 5 countries around the world. Over the past 4 years, the U.S. wind industry represented 35% of all new installed generation capacity. Wind energy will continue to be a fundamental component of the next era of energy projects to connect to the electricity grid. Interest in wind power continues to grow, with the proposed number of wind projects surpassing that of all other forms of generation. So I think we have to dig a little deeper to find the real source of the fear that these folks have expressed. What is it really that led to that? And how did that translate into intimidation? What, or more specifically, who, is really responsible for what's happening? We can start with Jerry Punch, who isn't a doctor, but who talks about adverse health effects based on what he claims other people have said. That, according to Punch, is based on what these other people have said in legal proceedings, and in proceedings like this. This is a quote. Some of this evidence is an expert testimony in legal proceedings, although I don't have any of that information to go through tonight. It's tedious. And during cross-examination, when he was presented with those tedious decisions, and several others, Punch claimed that he was not familiar with them. But there is one of those that is in this record. It's Pleasant Ridge Exhibit 87. It's a decision from a United States federal court from just last year, March 2014. It's in the case of Protect Our Communities Foundation versus Jewel. And Ms. Jewel is the Secretary of the Department of the Interior. And here's what this case says. The EIS, that's an environmental impact statement, the EIS subsequently discusses exposure to, they call it ILFM, infrasound and low frequency noise, above 85 dB, the accepted threshold for audibility, noting that excessive exposure to such levels has been associated with a condition termed vibroacoustic disease, a thickening of cardiovascular structures such as cardiac muscle and blood vessels. The EIS explains that risk of VAD is limited to rare situations such as military operations and work carried out in connection with the Apollo space program, where infrasound levels can reach 125 dB, vastly exceeding the levels of infrasound produced by wind turbines. Plaintiffs contend, however, that the EIS is deficient due to BLM's rare animation, refusal to accept the view that ILFM can have adverse effects on human health at pressure levels below the threshold of audibility. According to plaintiffs, and we've heard a lot of this here as well, inaudible ILFM has been documented to cause insomnia, vertigo, ear pressure or pain, fatigue, unsteadiness, dizziness, tinnitus, headaches, external auditory canal sensation, irritability, memory, and concentration loss, loss of motion, cardiac arrhythmias, stress, and hypertension. To support those allegations, plaintiffs rely on a scientific study conducted by Drs. Salt and Hull. And you probably don't remember this, but those are the studies that Phil tried to use with Dr. Ellen Hogan. Indicating that inaudible ILFM is powerful enough to stimulate the ear's cochlear outer hair cells, thereby causing significant annoyance and harm to human beings. Plaintiffs also rely on a study conducted by Dr. Nina Pierpont, which discusses wind turbine syndrome, an ostensibly medical condition caused by wind turbine noise. Dr. Pierpont's study suggests that ILFM for wind turbines causes significant health problems. Federal defendants and TUL, T-U-L-E, it's actually TUL, maintain that BLM did evaluate the evidence and expert testimony invoked by plaintiffs, but ultimately rejected it as flawed and unpersuasive. The court agrees. BLM relied upon epidemiologist Dr. Mark Roberts' expert opinion, which calls into question the scientific validity of the Pierpont study. Scientific evidence challenges the notion that adverse health effects from wind turbine sound are plausible. Dr. Pierpont's peer review process appears to be among colleagues and friends and not a single or double-blind process. Non-traditional references such as newspaper articles and television interviews are used to support Dr. Pierpont's hypothesis. BLM also invoked expert testimony from Dr. Arlene King the Chief Medical Officer of Ontario, Canada, disputing any connection between wind turbine noise and human health. The EIS does not, however, merely critique one particular doctor's theory, as plaintiffs contend. Rather, the EIS provides reasoned explanation and scientific support for BLM's conclusion that inaudible IL-FM emissions from wind turbines do not adversely impact human health. So Punch is part of the problem, but he's not the biggest example. He's just repeating what he's been told by people who are as unqualified as he is to provide medical opinions. And that starts with this book by Nina Pierpont. It really hurt to actually have to spend $20 to buy this thing. Not just by Nina Pierpont, let's not remember, by Nina Pierpont and her husband, Calvin, Luther, and Martin. Here's what we know about this book. Pierpont's a pediatrician. She's not an epidemiologist, a neurologist, an otolaryngologist, or an audiologist. She claims to have obtained information about 37 people. Punch actually claimed that she saw them in her practice, which wasn't true. He ultimately admitted that. She admits that she actually only spoke to 23 of them on the phone. She never met any of these people face to face. She never conducted an independent medical exam. And even she admitted the limitation of her methods. This is from the book. Despite what I see as the virtues of my approach, this study has clear limitations.
I have an objection. Is this book in evidence? I don't believe it is.
This is all in the transcript.
Okay, that's fine. I don't.
The excerpts that I'm reading from, Phil, is one of my exhibits. It was admitted during my cross with Dr. Punch. I can give you the exhibit number later if you want. Excerpts from wind turbine syndrome.
Okay.
So I didn't write down the exhibit number here. Anyway, as I was saying, despite what I see as the virtues of my approach, this study has clear limitations. One being that it was conducted entirely by clinical interview over the telephone. On the one hand, this had the benefit of allowing me to have an international group of subjects. On the other, it limited the type of data I could collect. As a result, my ability to say that a certain symptom during exposure is due to turbulence is confined to medical conditions which are diagnosable by medical history. A medical history is all information a patient tells the doctor about his illness, his past health and experience, and his habits. And despite that concession, and the acknowledged necessity for medical histories, Pierpont did not obtain medical histories from all the people she spoke to. Limited medical records were provided by the adults of families A and B, A1, B2, B1, B2, and by a young man in family C4. So that's 5 people on the 23 that she spoke to that she got medical histories from. I requested records for all families through ANF, but since no more were forthcoming, I stopped asking. And pursued those parts of the study not dependent on physical examination or test results, and for which I had a uniform study tool, the internet. And here's why she really stopped asking, because in a different section of the book, and again, it's in the excerpt, Phil, she identifies all of the symptoms that she found out about from these people, pre-existing symptoms, before they were ever, quote-unquote, exposed to a wind turbine. 8 adult subjects had current or history of serious medical illness, including lupus, breast cancer, diabetes, coronary artery disease, hypertension, atrial fibrillation with anticoagulation, Parkinson's disease, ulcer, and fibromyalgia. 7 subjects had history of mental health disorders, including depression, anxiety, post-traumatic stress disorder, and bipolar disorder. 8 subjects had pre-existing migraine disorder, including 2 with previous severe sporadic headaches that I interpreted as migraine. 8 subjects had permanent hearing impairments, defined subjectively or objectively, including mild losses limited to 1 year, or impairments of binaural processing. 6 subjects had continuous tinnitus, or a history of multiple discrete episodes of tinnitus prior to exposure. 12 subjects had significant previous noise exposure, defined as working in noisy industrial or construction settings, working on or in a diesel boat, truck, bus, farming equipment, or aircraft, military tour of duty or operating lawnmowers and chainsaws for work. 18 subjects were known to be motion sensitive prior to exposure, as defined by car sickness as a child or adult, any episode of seasickness, or a history of tour or episodes of vertigo. And after learning all of these things about these people that afflicted the subjects before exposure to wind turbines, Pierpont and her husband invented the phrase wind turbine syndrome to describe exactly the same conditions. And let's not forget, even Pierpont, the author of this book, which, by the way, you may or may not recall, Punch admitted remarkably, after he spent so much time talking about the virtues of this book, he admitted that he actually has never read it. Anyway, Pierpont admits herself that you have to go to a qualified doctor to determine what it is that somebody might have. Here's a quote. For those who read this report and recognize their own symptoms, the appropriate medical specialist to consult would be a neurologist or otoneurologist who is an otolaryngologist, ear, nose, and throat doctor, who specializes in balance, the inner ear, and their neurological connections. So that's Pierpont. Who else is responsible for what's going on here? It's a minor point, but Houston comes out from Virginia to scare all of you into thinking that you will be stuck with a massive decommissioning bill. The ordinance says that you have to have an estimate from a registered professional engineer. We went through some of that now, just a few minutes ago. And that's kind of like Pierpont's expert doctor. You need someone who's qualified to give you a decommissioning estimate. Houston, on the other hand, isn't a professional engineer. He has no construction experience, and he has no experience with decommissioning anything. You've heard from both our witness, Dave Rottman, and from Patrick Engineering that there haven't been any wind farms decommissioned. But there have been all kinds of other things decommissioned historically. Buildings, towers, water towers, and all kinds of things that professional engineers can use as examples to generate an estimate. Houston had no experience with anything like that. But frankly, that's not relevant in the context of spreading fear. It's really just about the narrative, the scary message, not the qualifications. So Dave Rottman says 37,000 plus or minus per turbine. Patrick Engineering says 63 and change, call it 64. But Houston, who has no qualifications of any kind, tells you that it's between $185,000 and $233,000 per turbine. Now, this is from someone whose opinion on decommissioning, remember, like you're going to remember. This is a guy who's testified many times before on this subject. His opinion has never been accepted anywhere. And we know why. It's not hard to get to his numbers. When you tell people that rather than the 9 to 12 months that Rottman and Patrick agree on, when you tell people like Houston did that it'll take 5.5 years. And it's not hard to get 5.5 years when you tell people that it's going to take 125 man-hours to flip a switch. But Houston really isn't the main source of the fear and intimidation. I view him as just a bit player. Maybe it's somebody like Groom. He never determined the economic benefits from a wind farm before. But of course he had no qualms about trying to go head-to-head with someone on the caliber of Professor Lewis. But his effort was much more important in terms of what he chose not to talk about. And this leads to the first and probably the most disturbing example of intimidation that's occurred in this county. We start with Pleasant Ridge Exhibit 302, because remember, Houston said nothing about Dr. Lewis's estimate of the financial benefits to Prairie Central School District. Nothing. Didn't touch it. So we start with Pleasant Ridge Exhibit 302, which is the Prairie Central Community Unit School District Number 8 Board Goals. And here are the board goals. Formulate a plan to reduce staff commensurately with declining enrollment and loss of revenue. Prepare a cut list for the succeeding school terms, amounting to roughly $2 to $2.5 million in response to reduced general state aid and categorical reimbursement losses, Illinois financial crisis. In light of declining enrollment, develop a plan for the reduction of facilities and consolidation of students, building closure, attendance centers. Communicate to internal and external populations the need for downsizing in staff and facilities and the need for bond conversion. And on the heels of that, this happens. Pleasant Ridge Exhibit 306, the Prairie Central Board meeting minutes from August 21, 2014. Superintendent Capasso reported the following. Pleasant Ridge Wind Farm. Capasso reintroduced the topic and referred the board to reading material produced by the Center for Renewable Energy, Illinois State. The question remains as to the net result of the interaction between a wind farm's assessment and general state aid. The board will consider a resolution on the matter after additional fact-finding and hopefully a visit from an expert on the matter at a future meeting. And this one reflects guests present. Where do I put it? None. Now we go to the next month. It's Pleasant Ridge Exhibit 185, September 18, 2014. First, it's now a packed house with guests present. A lot of people in this audience. But it started with Dr. David Lewis and an individual named Matt Alderman, presenters for Center for Renewable Energy, Illinois State University. But then there's a list, as I said, of a whole bunch of other folks. And then it starts. Marcus Meyer asked Dr. Capasso who authorized him to give a public opinion about Pleasant Ridge, and whether or not the presenters had biases on wind energy. The board suggested that comments or questions specifically regarding the Pleasant Ridge Wind Farm be held until the presentation. Then under finance, Dr. Lewis makes a presentation, made a detailed presentation, and fielded questions and comments on wind energy. And then there's a list of some of the guests who were present who start saying the same things that you've heard here for the better part of 7 months. Property value impacts, health impacts, you name it, they talked about it that night. At the tail end of the finance discussion, proposed bond issuance. The board will take up the matter of bond issuance at its November meeting. The amount earlier proposed is $4.33 million with payoff over 3 years. The next one is Pleasant Ridge 183, October 16, 2014. Again,
Mike, I apologize. What number was that?
183.
Thank you.
Sure. Public comment. All comments were about the proposed Pleasant Ridge Wind Farm. Brad Steiger, Steve Canal, and Nate Kelson. And under finance, proposed wind farm. Having heard information about the proposed Pleasant Ridge Wind Project at 2 meetings and considered the advantages and disadvantages for not only the school system but also residents, the board declared its position to be neutral. So you never heard from Dr. Capasso. This is what Dr. Capasso wasn't allowed to tell you. Pleasant Ridge Exhibit 303, January 15, 2015. Moved by Schlatter and seconded by Dowder at 7:06 p.m., we enter a public hearing concerning the intent of the Board of Education to sell $4.330 million in working cash fund bonds. President Hammercorn stated the purpose of the hearing. Superintendent Capasso gave reasons for issuing $4.33 million in working cash fund bonds. Deficit spending in education, transportation funds. Significantly reduced state funding. Widening gap between the cost of educating needs of children and revenues. diminishing working cash fund. And here's a really telling comment. Asked for written and oral comments from the public on those issues, received none. And that's despite the next statement in these minutes. Finance. With word that personal and corporate income tax rates will be rolled back, state funding for schools will be further reduced for the current fiscal year. It is estimated that Prairie Central will lose an additional $1.1 million, forcing the use of $1.8 million in working cash funds to cover deficits in education and transportation, rather than the budgeted $700,000. And then finally, just this past March, Pleasant Ridge Exhibit 307. March 19, 2015. The discussion is all about the financial mess and not about the wind farm, so no local residents were present. Moved by Slagle, seconded by Dowder, that we approve a resolution providing for the issuance of $4.330 million in taxable general obligation school bonds, Series 2015, for the purpose of increasing the working cash fund of the district, providing for the levy of direct annual tax, etc. And what do we have for Dr. Capasso's report on finance? Categorical payments. Categorical payments have virtually stopped. Only the lunch program appears to be active presently. The ISBE has informed superintendents that districts should expect few categoricals for the rest of the fiscal year, but that all 24 payments in general state aid are scheduled. The information, if accurate, will enlarge Prairie Central's loss of state money since 2011 from $1.76 million to $2.5 million. Now, we do have an example of what happens when intimidation isn't a factor. Because nobody got to the Tri-Point School District. So you heard from Superintendent Jeff Dorgan, who came here with his entire school board to tell you that even $35,000 matters. And for Prairie Central, we're talking about a whole lot more than $35,000. But getting back to Groom, like Houston, again, he's just another bit player. And nor, frankly, it becomes a surprise to you, nor do I actually blame the people who muzzled Dr. Capasso. That, again, was the result of the fear that came from somewhere else. And you may be really surprised to hear this coming out of my mouth. But I don't think the blame lies with Ted Hartke either. Hartke's a victim of the same fear-mongering that you all have been subjected to. And you know the story. 3 months of promises to get quotes for soundproofing. 3 months when Invenergy consistently turned off the turbines near his house just because he asked for it, without any proof that there was anything wrong. 3 months of what turned out to be false promises by him. And then we get to this process, and what do we hear on cross-examination? He won't identify the contractors he claims to have spoken to. He won't identify the employee of the construction company that he says gave him the idea to demand that Invenergy buy his house. And most important of all, he won't identify the doctor who can substantiate his claims. Remember, that's even what Pierpont's recommends. Go see a qualified doctor. But actually, we do know there is a doctor for the Hartkes out there. It's just that he or she will not support what Hartke claimed here. This is Pleasant Ridge 136. It's Hartke's script for his presentation to Boone County in May 2013. Here's what he said. Our son had a pre-existing sleep problem, and we've been seeing a specialist for 2 years now. That's 2 years before the wind farm got there. Up until the turbines went live, Philip's symptoms had been improving dramatically, and in early January, at his last checkup with the specialist, we had discussed weaning him off sleep meds. Since the turbines turned on in January, Philip's symptoms had been gradually returning to becoming worse. That's what he says. So a medical professional clearly diagnosed Mr. Hartke's son with a pre-existing sleep disorder having nothing to do with wind turbines. But when it came time to provide any link between that pre-existing condition, or anything like it, and what Harkey now is complaining about, what do we see? Pleasant Ridge 237. The letter from the Vermilion County State's Attorney, speaking on behalf of the Vermilion County Board, who Harkey then says, of course, are all liars. And here's what the State's Attorney says. January 9, 2015. No medical or scientific evidence has been forwarded to the Vermilion County Board to substantiate any medical issues related to the operation of wind farms in Vermilion County. And let's not forget Harkey's school superintendent, Bill Mulvaney. You had the original letter, a couple of people gave it to you, where he claimed to have been told information that Harkey's children were suffering from sleep deprivation due to wind turbines. What you didn't get from anybody else, what you did from us, was Pleasant Ridge 236, the Vermilion County Board's response to Bill Mulvaney. The county also attended meetings elsewhere and spoke to school superintendents and met with other officials to gain from their experience. None of the comments made by you seem to reoccur in Bloomington or Champaign. We appreciate your comments, and if you have more specific information, we would be happy to forward it to the appropriate persons. My experience in court shows that judging cause and effect should be carefully done. Other communities observe no such issues, and even here, other residents have no such complaints. Now, we know that Mr. Mulvaney didn't provide any such information in response to the board's invitation, because that's the first line of Pleasant Ridge 237. To confirm our recent conversation with regard to Mr. Mulvaney's letter, we have not received any report from a licensed physician or qualified medical person to substantiate any of the points raised in Mr. Mulvaney's letter. And where did Mr. Mulvaney actually end up on the issue? That's Pleasant Ridge 123. Nowhere was the nowhere was the wind farm windfall bigger than in Armstrong, where a school system which barely tops 200 students raked in more than $1 million in new tax dollars. That's more than a third of the system's $2.9 million in total revenue last year. About $1.5 million of that was local property tax revenue. Superintendent Bill Mulvaney said the wind turbines more than doubled the school system's equalized assessed valuation. They have been a huge boom, and from a financial point of view, they will keep us alive for a minimum of 10 years, said Mulvaney, who knew the big payday was coming. How does Harkey deal with that? Does he provide any medical support for his claims? He doesn't. As I said, he calls the Vermilion County State's Attorney and the county board liars. Why was he so unwilling to disclose medical information to them or to you? Do you really think, having seen him, that if he had it, he wouldn't give it to you? And why at the same time was he so willing to accuse the Vermilion County Board and the Vermilion County State's Attorney of being liars? Because his rhetoric doesn't match the science. How do we know that? Because there is evidence in this record, at least 3 forms. Apart from all the studies from around the world that Roberts bored you with on November 18th. Let's start with a question that Phil asked of Dr. Ellenbogen. And would we all agree that the World Health Organization is a reputable body? Answer, very. This is Pleasant Ridge 295. It's an excerpt from the WHO noise guidelines for Europe. And I covered this with Punch, and Hankard testified about it as well. The WHO guidelines address outdoor and indoor conversions because the measurements are always outside. And you have to convert them to determine what the levels are inside, because if you're going to talk about sleep disturbance, you have to know what the levels are inside what people are sleeping. And in the chart that they have, they ultimately, considering all the factors, they end up with a reduction from the outside number to the inside number of 21 decibels. So for example, if you're at 45 outside, you're going to be at 24 inside. And according to the list of the WHO guidelines, they have a list of decibel levels and what can result from those levels. At 30 dB or below, you are at a level, below the level where there are no substantial biological effects. Now, we don't have indoor measurements from Hancock because Hartke moved one in the house. Anybody on Schoenhard's property either. So we have to rely on the WHO's outdoor to indoor conversions. Or do we? Proof of the pudding. Here's another surprising one. We can rely on this Cape Bridgewater study. Hancock mentioned this, page 187 of the study. Conducting noise level measurements inside dwellings, where the background level is often below 20 dBA, presents an issue with respect to the noise floor of the instrumentation. In other words, it's so quiet inside those houses, even with the turbines operating, that their meters are bottoming out. But most important, what they're seeing inside those houses is levels well below the level at which the World Health Organization says no substantial biological effects. Second source of the evidence is the study that was conducted just a couple of months ago. It's Pleasant Ridge Exhibit 325. Health-based audible noise guidelines account for infrasound and low-frequency noise produced by wind turbines. Among the authors, and this name was mentioned a couple of times, Jeff Leventhal, who's one of the most renowned acousticians in the world, and reviewed by Timothy Joe Wade, United States Environmental Protection Agency. What's the conclusion of that study? And it's important, remember, it's been suggested here that even if we meet the IPCC guidelines, that might not be enough, because there might be some health impact, regardless of whether we meet it or not. This is what that study said. The purpose of this paper was to investigate whether current audible noise-based guidelines for wind turbines account for the protection of human health, given the levels of infrasound and low-frequency noise typically produced by wind turbines. They go through it all. However, this corresponded to an overall audible increase, supporting the hypothesis that controlling audible sound, in other words, meeting the noise guidelines, produced by normally operating wind turbines, will also control for low-frequency noise. Overall, the available data from this and other studies suggests that health-based audible noise wind turbine siting guidelines provide an effective means to evaluate, monitor, and protect potential receptors from audible noise, as well as infrasound and low-frequency noise. But there's even more direct evidence that these anti-wind groups use people like Hartke to pursue their own ends. Someone who wasn't here, but yet spoke the loudest about what these people with a political agenda are willing to do, how they will use anyone. And that's an individual from Michigan named Carrie Chanel, the 53-year-old industrial designer. What did Punch try to tell you about Chanel? Question: when you referred to this slide last month, you said one of the houses belongs to an individual named Carrie Chanel near Ludington, Michigan. Is that correct? Answer: in Mason County, yes. Question: and it's your opinion that he was suffering from wind turbine syndrome? Answer: it is. Question: you've met personally with Mr. Chanel? Answer: I've met him a couple of times. And you heard from Dr. Ellen, eminently qualified, compassionate, caring, and most important, outraged at what people like Punch do. Again, qualifications do matter. And Dr. Al Hogan actually, unlike anybody else you either heard from or heard about, actually did conduct a full, independent medical examination of that 53-year-old industrial designer. And what was the diagnosis? Obstructive sleep apnea and irregular heartbeat. So Punch tried to bring Alan Logan down to his level. This is on January 22nd. Question: And is a report issued by those agencies inherently biased in favor of the wind industry? Answer, I don't know. Some of these other people, Dr. Ellenbogen certainly has testified on behalf of the wind industry many times in many places. Question, Dr. Ellenbogen has testified on behalf of the wind industry many times in many places? Answer, I think he has. Question, really? What do you base that on? Answer, well. Question, what do you base that on? Answer, it's my understanding that he has. I know he participated in this one. Question, you said many times in many places. What do you base that on? Answer, I don't have, okay, I don't know what states. I understood he was testifying in a number of states. Question, who told you that? Answer, I don't know, I don't know. I don't have any definite factual information. My impression was based on information from sources I don't recall, but it's not worthy of discussion here. I don't think in terms. Question, oh, I think it's very worthy of discussion. Question, let me try it this way. Do you have any information to suggest, imply, or confirm that Dr. Ellenbogen has ever, in his entire career, testified in any proceeding other than his testimony in this proceeding? Answer, no, I don't. But it's not really a discussion here. Ultimately, Punch had to admit what we all saw. Question, so you tried to check it out? Answer, I was impressed with him, okay? Question, he's an impressive guy, isn't he? Answer, he's an impressive guy. Anyone who's met and heard Dr. Ellenbogen doesn't need someone like Jerry Punch to tell them about his humanity. And if you need any more substantiation, you have it in the most extensive, real, complete study ever conducted on the impacts of wind turbines on health. Pleasant Ridge Exhibit 63, the November 2014 Health Canada Study. This is what Dr. Ellenbogen said about that study. In that study, they looked at not only at a medical literature review, which is a study, but it's not really a study. It's really an examination of existing knowledge. Where this Health Canada study, they actually did physiology, measuring sleep, cortisol levels, sound pressure levels of wind turbines. And this is in Canada, has the Health Canada label. And they did not show relationship between sleep problems and noise from wind turbines. Here's the conclusion from that study. While it can be seen that many variables have a significant impact on measured sleep, calculated outdoor wind turbine noise levels near the participant's home was not found to be associated with sleep efficiency, the rate of awakenings, duration of awakenings, total sleep time, or how long it took to fall asleep. Punch tried to twist that one as well. Here's an example of what he described as his lack of bias against the wind industry. Question, WTN, which is what they use for wind turbine noise. WTN annoyance was found to be statistically related to measured long-term cortisol levels and systolic and diastolic blood pressure. That's under slide 21, right? Answer, right. Question, and that's what you quoted out of the Health Canada report, right? Answer, yes, under the title annoyance. Stress and AHEs, adverse health effects. Question, right, okay. And remember last night when we were talking about this, you characterized this quote that you quoted in your slide as an admission. Do you remember saying that? And then he says he doesn't remember, so I read it to him where he says it was an admission by Health Canada that there were these impacts. Do you remember testifying to that last night? Pretty much yes. Okay, so first, since you have the Health Canada study there, this quote that's in your slide, what section of the Health Canada study is that from? Answer, self-reported questionnaire results. Answer, all right. And you do know that's not the principal conclusion of the study, don't you? Answer, he's trying to fight on this. Answer, no. I selected this to make a point that even your own exhibits indicate there is a relationship between physiological measures and wind turbine noise. Question, all right, well, why don't we see what those people said about the line you quoted? It's at the top of page 3. For the record, Mr. Punch, Dr. Punch, it's 5-3, that's the second bullet. Answer, gotcha, thank you. Question, okay. That's the one you elected to quote for the zoning report, correct? Answer, yes. Question, okay. Now, if you go to the top of page 3 of the report, and here's what Health Canada said about the part that you quoted from the questionnaires. The following were not found to be associated with WTN exposure: self-reported sleep, e.g. general disturbance, use of sleep medication, diagnosed sleep disorders, self-reported illnesses, e.g. general disturbance, use of sleep, self-reported illnesses, e.g. dizziness, tinnitus, prevalence of frequent migraines and headaches, and chronic health conditions, e.g. health disease, high blood pressure, and diabetes, and self-reported perceived stress and quality of life. While some individuals reported some of the health conditions above, the prevalence was not found to change in relation to WTN levels. And then I asked her, now, was it your decision to quote a portion of this report that the study rejected, or did someone else ask you to do that? The answer, nobody asked. And the fear mongering doesn't just apply to humans, it even spread to livestock. And again, I was going to say, you may remember, but it was back in November and January. Terry Vanderwall, an eminently qualified biologist, wildlife biologist, talked to you about the fact that there are no impacts. And not just based on his expertise, but on the real world experience of two veterinarians who practice in the midst of wind farms in the land. So where else does the fear come from? Well, they also tried to make it come from a small cluster of anti-wind acousticians. From Rand, Ambrose, James, and Schomer. Remember, it's Ambrose who worked on Hartke, and it's Schomer who Hartke wanted us, Invenergy, to hire in the California Ridge oyster. Why did Hartke want him? Schomer's theory about direct physical contact. It's what Pierpont talks about too. And they tried to use Schomer to support his theory.
He cannot test it. And there is no evidence in the record as to why Hartke wanted Dr. Schomer to test, to represent him. That's not in the record whatsoever.
I'm allowed to extrapolate the closing argument.
It can be Mr. Blazer's opinion. He can state it as his opinion, but he can't state it as a fact.
All right, fine. It's fine. Anyway, the theory that Schomer and Pierpont generate has been completely discredited by the person who actually developed that theory. His name is Dr. Neil Todd. And I asked Punch about this when I showed him our Exhibit 56, which is that big, fat environmental impact report from that Thule Wind project, which ended up being the federal decision that I wrote to you a little bit earlier. Question, and you and Mr. James and Ms. Pierpont all rely on the work of Dr. Neil Todd to support your theory, right? Answer, yeah, I mean, yes. This is fine for now. You refer to him as a matter of fact in Pleasant Ridge 292, the Audiology Today article that you wrote with Mr. James. That's correct. Question, and you know the next question. I think you've been asked it before. You do know that Dr. Todd, who you rely on, has rejected your interpretation of his research, right? Answer, I know he's rejected Pierpont's book's interpretation. I didn't know he rejects my interpretation. Question, have you read his rejection of this VVVD theory? Answer, I've read that he rejected it. I'm not sure I've read a complete statement. I don't know if he wrote an article. I'm aware that he rejected it. Let's see if I can refresh you a bit, because this has been quoted in a number of different places. It's at the bottom, and I refer to a page. The work of Dr. Pierpont relied heavily on the research of Dr. Neil Todd from the Faculty of Life Science at the University of Manchester, who recently reprimanded Pierpont for her misinterpretation and use of this research, of his research. Pierpont's wind turbine syndrome theory has incorrectly sought to insert airborne noise issues into a paper that is entirely about vibration through direct contact with the skull. Dr. Todd states the following concerning Pierpont's interpretation of his research, and this is the part I want to focus on to see if this is what you've heard before. I'm talking now Punch. And this is quoting Dr. Todd. Our research is being cited to support the case that wind turbine syndrome is related to a disturbance of the vestibular apparatus produced by low-frequency components of the acoustic radiations from wind turbines. Our work does not provide the direct evidence suggested. We described a sensitivity of the vestibular system to low-frequency vibration of the head through direct physical contact at about 100 hertz and not air-conducted sound. That's what we've heard or read before. Is that correct? Answer, right. It's also explained, I'm not going to read the whole thing because I'm probably close to where I said I was going to be done anyway. I'm nowhere near it. Pleasant Ridge 299, written by that expert, Dr. Jeff Leffel. It's actually his testimony in a proceeding in Wisconsin, where he says basically the same thing, except for one thing. This I will read. There was publicity on Pierpont's work on 2nd August 2009 in a UK newspaper, as this article referred to his work. Todd finally came out and repudiated Pierpont after use of his research. The response from Dr. Todd was published on 9th August, and shortly after this, all references to him disappeared from Pierpont's webpage. But 6 years later, you're still hearing about it. And what did Schomer, the person who Harkey wanted, say about the California Ridge study? This isn't all of it. It's the cover. There's his name on it. In summary, no turbine-only noise levels exceed the IPCD limits. And the average of the turbine-only noise levels measured when turbine operations were at or near maximum are 45 dB in the 500 Hz octave band and 39 dB in the 1000 Hz octave band. These levels are 2 dB below the limits of 47 and 41, respectively. Now, that of course takes us to this notion of sensations in that Cape Bridgewater study that you heard so much about, where people were complaining about sensations when the wind turbines were turned off. And a lot was made of the fact that a wind company paid for it, as if that's some admission of something. And it actually is, just like when Invenergy agreed to hire Schomer at Harkey's request. It's an admission that the wind industry is not in the business of hurting people and has nothing to hide. So they cooperated completely, and the result was complaints when the turbines were shut off. But to folks like Randy Schomer, that doesn't matter. It's still all about the narrative. And just look at what the principal opposition witness who spoke about the Cape Bridgewater study said to you. I reviewed the study. I've read the executive summary. I've read the conclusions, which are both pretty long. I've read parts of the narrative. I've read parts of it. I haven't read it all. I don't think anybody has at this point. That was punching. Once again, touting the virtues of something that he didn't believe. You only heard from one person who had the training, the experience, and the patience to read the entire study, and that was Mike Hancock. Anyway, let's go back to those acoustaticians that we're told would say that Invenergy did something wrong or was doing something wrong. We never did hear from Randy James, and we all know why. Punch confirmed how the folks who are behind what happened here operate. Following the rules of public meetings does not work. The meetings are A, a charade, B, a farce, C, a hoax, and D, altogether a mockery of public participation. You see, these folks, even Harkey, do just fine when they can spread their opinions without risk of being called to task, like at a town hall meeting last June in this county, without risk of actually having to back up what they say. And as Mr. Bunting pointed out, when Harkey was done with his presentation, he wouldn't name the contractors, he wouldn't name the guy from White Construction, he wouldn't name the doctor, but he had no problem naming Sean. And that, unfortunately, is the effect of single-mindedness, of what some people call the tyranny of certainty. I must be right, I can't be wrong. Everyone else is wrong or is a liar. And folks like that can't face the possibility that they just made a colossal mistake, and that they've dislocated their families in the process. And so children get used. We all know children are very impressionable, particularly when it comes to their parents. And I'm struck in that context by one of the things about Harkey's story about his little girl. At the dentist's office, here's what he said. My daughter drew this after a dentist appointment on March 6th. I took her to the dentist appointment. We got back to my office. She does her thing, grabs the colors or whatever, pens and highlighters is all I have, and she made this. And I thought, oh my God, I didn't know what to think about this. So Harkey wants us to believe that this little girl came up with this on her own, no coaching, no parental involvement, but then of course ignores what we've all seen every day of this hearing. You get the people who are really responsible for what happens in situations like this, and what happens. Again, we all know what happened with Andrew James. So we move beyond all those claims about health impacts, and we come to the other thing that scares the heck out of people. It's been said that a person's home is the largest, most significant investment they can make in their entire lives. So it's completely understandable that people who hear their property values will drop by 25 to 40% are going to freak out. And in the hands of the right people who have their own political agenda, that fear can be used to influence. So let's start first with the facts. Professor Thayer and Mike Bruce. A slew of studies, tens of thousands of transactions, no statistically significant impact. And in response to all that, we get McCann. And let's not forget that like Punch, he used Chanel too. The first slide you see here, you may have heard the name before, is a residence in Michigan belonging to Carrie Chanel. This is also a property that I had some experience with going back to June 2011. And by the way, I also reminded you of one other thing. It's been a while since I've testified before this board. I'm not sure if it's any of the same members or new members, or if you're, I'm not remembering all the names and faces, but I did testify previously with the Zero Run Project. Now, we have a lot of issues with what was exciting here. And what he tried to do was contrary to every accepted methodology recognized in the real estate industry. But there's one thing he said that is most fundamentally the reason why you've sat through 7 months of this. This is from February 18th. Okay. You also said on your slide 26 as your second bullet, perception of wind farms will be a key factor on how much more loss could be realized before the market stabilizes. Does that sound right? That's what you said? Answer, sure. Question. And I think you said when you were talking about that statement in your slide, that until we find a way to change the perception, then I think you said the impacts will continue or something like that. Does that sound like what you said? Answer, yeah. Yeah, basically what I'm saying is if my report is based, the effects are because of the wind farm, then we do have some adverse effects from that, and we would need to address that somehow. So you need to address the perception. Well, perception is a key element. Yeah, right. So for example, if somebody provides false information that leads to potential buyers to believe their investment in property near a wind farm is a bad idea, property values will go down, right? Answer, yes, that would be correct. And now you know why the anti-wind folks work so hard to spread their message of fear as much as possible. And it's not really just about the fact that McCann will say anything his clients want him to say. Like a facility that's overrun by rats won't have a negative impact on surrounding property values. No, with McCann the problem goes a lot deeper. For McCann, it's part and parcel of the political agenda that's behind all of the stuff I'm talking about, all of the stuff you've heard for 7 months. This is Pleasant Ridge 186. It's an excerpt from a presentation we did March 20th, 2013 in Indiana. And you may remember that I walked you through this. Anti-wind activists or lobbyists? No. Independent appraiser bound by the USPAP. Characterization, claims, or allegations to the contrary are false. Well, except for what he did April 15, 2013, a letter to the U.S. House of Representatives Committee on Ways and Means lobbying against the extension of the federal production tax credit. And you know what, I just have to say, lawyers don't like to use this word. Harkey had no problem with it. We don't. But there's no other way to describe McCann as anything other than just a bald-faced lawyer. And he's not just a simple lawyer, because his eyes are on both. This is a guy who commits perjury. From something as silly as misrepresenting the fact that the Appraisal Institute never peer-reviewed his webinar, to a couple of things that are a whole lot more serious. Pleasant Ridge Exhibits 197A and B are the MPAC study, the Ontario study by the organization from 2012. Here's what McCann told you it says. And again, you may remember, you may not. He had a presentation where he has the cover of that report to make it seem like everything else after it comes from that report, except that it didn't. He created it. Here's what he says. Less than 1 kilometer, 25% negative impact. 1 to 3 kilometers, 26.3% negative impact. 3 to 5 kilometers, 21.1% negative impact. Here's what the study actually says. To further confirm its findings, MPAC also conducted an additional analysis using approximately 2,000 sales and resales following similar logic to the Lansink, L-A-N-S-I-N-K study. That's one of the studies that McCann was trying to provide. The main differences between the February 2013 Lansink study and MPAC's resale analysis is the sample size and the determination of the increase in the market between resales. Using 2,051 properties and generally accepted time adjustment techniques, MPAC cannot conclude any loss in price due to the proximity of an industrial wind turbine. Of the 2,051 sales used in MPAC's resale analysis, now remember what I told you, not what I told you, what he told you about these percentage drops. Here's what MPAC says. Of the 2,051 sales used in MPAC's resale analysis, 2,002 had higher second sales. 9 sold for the same price twice, and 40 sold for less the second time. Of the 40 that sold for less the second time, 39 are outside 5 kilometers, 3 miles, of an industrial wind turbine. 1 is within 2 to 5 kilometers, 1.2 to 3 miles, of an industrial wind turbine, and none are within 2 kilometers, 0.6 of a mile. That means 97.5% of these properties sold for more the second time. But as you said, Mr. Chairman, a few times, you want to know about what's happening in Livingston County. So there's that infamous house in Flanagan. Now, we can't really forget about the mattress floating in the basement or the mold on the walls. But let's give McCann the benefit of the doubt on that one and say it might have been a simple mistake. He didn't knock on the door. It's inexcusable when someone is doing what McCann said he was doing. But let's put it aside. Here's what McCann said to you about that property. Question. Now, you had mentioned earlier this evening, sort of in response to one of my questions, something about T1, 2, and 3. Answer, yes. Question. And I kind of lost track. I was focusing on you rather than taking notes. What was your point about T1, 2, and 3? And as you may have guessed, I was simply debating him to try and get him to repeat the answer. Answer. You were asking about resales, and I was describing that that's a property that was sold and resold, and in fact, resold again. The property sold 3 times, so it resold twice. And the more recent sale showed the biggest drop after the turbines were built. Question. And actually, those 3 sales you specifically called out in your report. Answer, right? Answer, I did. Question on page 29, first paragraph of your report. Answer, I think I still need these. Yes. Question. And what was the point of your discussion in this paragraph in your report? Answer. Well, the paragraph is fairly self-explanatory, that it's sold 3 times. Its target sale T1, 2, and 3, losing value each time. But the first sale was in 2009 while the Manat project was pending. And what I'm addressing here is what somebody remembered or referred about the Hinman study that was done in 2010 by the Twin Grove Wind Farm in McLean County. And what the ISU student Jennifer Hinman had opined is that something called wind farm anticipation stigma theory, because in her study she was finding that before the turbines are actually built, the property values are dropping to some degree. But then she goes on to say that after the projects are built, that the property values soar. And that's not what this resale shows. This shows after the project was built, the property value dropped 28%, which that's not soaring in my book. Question. And it's your opinion that those price drops are due exclusively to the proximity to the wind farm? Answer. It's perfectly consistent with what the majority of the data shows. Yes, sir. That last sale that was so central to McCann's testimony happened in February 2012. And the Manat wind farm didn't even start construction until months later. How does McCann justify creating a wind farm that doesn't exist? He had every opportunity to justify it, or to explain it, or to apologize for it. We were told that he might be back at survey level, but he never materialized. You know, there are really only 2 ways that you can deal with something like that, especially in the north. You can either face up to it and take your loss, or you just stay away. And I suppose it's no more than we should expect when McCann is faced with the second Marouse report, Pleasant Ridge 312, the assessed valuation study. And I suppose Phil did the best he could under the circumstances with Marouse. He tried to challenge him on a few of the comparables. He also tried to quibble with him about how much a shed might be worth. But there were 2 subjects Phil avoided: that impact study and that missing wind farm. And there's something else you can't avoid. 18 counties in Illinois, 1 million properties, and 1 conclusion. Without exception, the interviewees reported that there was no market evidence to support a negative impact upon residential property values as a result of the development of and proximity to a wind farm facility. Either as a request by a county board in an attempt to appropriately assess newly constructed residences, or to support currently assessed values, the supervisors of assessments have been particularly attentive to market activity in the area of the wind farms. Exclusive of 1 tax appeal filed in Vermilion County, the assessor's offices have not experienced a tax appeal based upon wind farm-related concerns. As the available market data do not support the claim of a negative impact upon residential values, residential assessed values have fluctuated consistently countywide as influenced by market conditions, with no regard for proximity to a wind farm. Agricultural properties are taxed based upon a productivity formula that is not impacted by market data and external influences. And again, Mr. Chairman, referring to your statement that you want to hear about the situation in Livingston County, here's what your own assessor had to say. Each of the interviewees was familiar with the wind farms located within their respective county. Livingston County Supervisor of Assessments, I'm going to really butcher this last name, Mr. Dwayne Kieswetter, formerly had lived within approximately 0.75 mile of the wind turbine. He stated that he was able to hear the wind turbine in the distance, but he had no concerns. But again, we really can't even lay the entire blame on McCann's feet. He's just a functionary. A bad one, but he's just a functionary. And where I think it gets us to, I'm going to quote you again, Mr. Chairman. I, however, would like to warn each of you that as you testify, your testimony is subject to cross-examination. Be careful as you include evidence in your conversations that you may or may not understand, as you could be questioned about it. If you make a reference to a fact, I will have to allow any line of questioning regarding it. Additionally, I ask that you somewhat vet your sources. Much of the testimony and comments by all involved has revolved around the internet. I understand it is a great tool, very efficient and generally reliable. However, I'm here to tell you that for everything you read on the internet, there is another internet source that will contradict that first source. Consider the credential of each source and weigh in your own mind if you feel it would be a believable source. After all, you are putting your own name behind your opinion as well. And there finally is where the real fault lies. With the biggest game of telephone in human history. Some of you are as old as I am, some of you are a little bit older. Game of telephone. Johnny fell on the playground and scraped his knee. And by the time it makes the rounds of the school, Johnny has an amputated leg and he's on life support. And some folks have figured out how to take full advantage of that. Punch talked about the position of the anti-wind movement, the organized movement. Don't install wind turbines anywhere. Wind really isn't an economically viable source of renewable energy anyway, when you look at the financial aspects of it. And all the government subsidies should just simply stop. And we have the Society for Wind Vigilance, Pleasant Ridge Exhibit 274. Look at some of the names on that list. Names that popped up in these hearings, but of course, none of these people testify here, probably because it was too tedious. Nissenbaum, James, Salt, Thorne. And Punch identified the rest of the anti-wind groups for us. Here's a part of that list. It's Pleasant Ridge Exhibit 282. The list from National Wind Watch, opposition and action groups. And if we follow your request, Mr. Chairman, again, just to focus on the local area, right there is Illinois Wind Watch. Okay. Let's get to special use factors. Special use factor number 1 is consistent in all respects with the Livingston County Comprehensive Plan and the Livingston County zoning ordinance. The County Plan Commission said yes 3 times before this. Including most recently in 2010. Excuse me. That one is attached to our Plan Consistency Report. The Livingston County Regional Planning Commission has reviewed Heartland Wind LLC's special use application to Livingston County for a wind energy conversion system. The proposed Heartland Wind LLC project consists of approximately 165 wind energy turbines and electrical transmission lines. The land proposed for the wind energy turbines and other infrastructure is used for, I'm reading way too fast, I'm sorry. Is used for agricultural purposes and located within the Livingston County Ag Agricultural Zoning District. Section 5.2 of the ordinance identifies windmills as a special use in the Ag Zoning District. The application for special use has been referred. This document constitutes the Commission's report to the Zoning Board. A primary goal of the comprehensive plan is to preserve and protect farmland from the continued agricultural use. The comprehensive plan calls for maintaining the rural character of the county by planning for the preservation of prime agricultural land. Just tell me to slow down, otherwise I do that. And for supporting the preservation and expansion of agricultural and natural resource businesses. The proposed Heartland Wind LLC project is located across parts of Esmond, Sunbury, and Hansing Townships. The project proposes to use approximately 1% of leased land for the wind farm, leaving the remaining 99% for agricultural use. When the REX project terminates, the turbines, access roads, and other infrastructure must be decommissioned and removed from the land. Accordingly, while the REX project during its proposed development will remove a small proportion of the project area from agricultural use, the proposed special use is generally consistent with the primary goal of the comprehensive plan to preserve prime agricultural land. This report was prepared and approved by the Livingston County Regional Planning Commission. I can't tell what the vote is. With the Livingston County Regional Planning Commission recommending to the zoning board of appeals as a condition of approval, zoning case, etc., that the applicant Heartland Wind offers a good neighbor program to offset any perceived detriments, etc. And they said that project was, just like the two before it, was consistent with the comprehensive plan. Now, for the first time, your plan commission said no. For the first time before, they said no. Let's look at what happened. First, let's look at what happened when Chuck Shope announced that that plan commission meeting was coming up at the hearing immediately before that plan commission meeting happened. We're going to review this, but there's no testimony given. That's basically a discussion between me and not a public meeting. I'm the only one that speaks, so unless they have questions, so it's not an open forum for questions and answers from everybody else, just kind of a closed issue. People in the audience are disturbed about it. Audience voice. Is there a public comment allowed? At the end of the meeting, after a decision may have been made. Ms. Gerber, on the issue of the Regional Planning Commission meeting, if the objectors were going to present witnesses, would they present them then, or are you not going to allow any witnesses from anybody else? Mr. Shope, neither side is going to have any witnesses. And at the very, very end of that discussion, there it is, Ms. Gerber, okay, I know what to tell them. Now what actually happened? This is from the recommendation that's in this record. Here's the recommendation from the report. Livingston County zoning case, SU 714, that what is presented in the Pleasant Ridge Wind Energy application is not in compliance with the Livingston County Comprehensive Plan. How did they get to that limited conclusion? Page 3. During this Planning Commission review, it was noted that concerned citizens had not finished providing information at the Zoning Board of Appeals hearing, and it was pondered as if more evidence is needed to be presented to allow for a complete RPC review. Also on page 3, Mr. Shope presented his report regarding the zoning case, etc. Transcript from November 18, when Joanne Blank presented her point consistency report. Copy of the transcript from December 8th, hearing held by the Livingston County Board of Appeals, in which the comprehensive plan compliance is questioned. At this December 8th meeting, a group of interested citizens questioned the proposed use regarding health, aesthetics, and property values. Page 4. Ms. Woodburn expressed her concerns about this impact statement when she compared this information to the information provided in the IDNR report regarding this zoning case. Now, the IDNR report is about endangered species, not about your comprehensive plan. Pages 4 to 5. Planning Commission member Keith Baylor mentioned that he had attended some of the zoning board of appeals hearings for this zoning case, and he expressed his concerns. The residential goals of the comprehensive plan were mentioned, and how the proposed development could have an effect on residential development and property values. The review of past projects was mentioned, along with a discussion relating to setback distances. So now we're getting into the issue of county wind ordinance and objections to current setbacks. The project's effect on value was mentioned, as was perception issues. Planning Commission member Richard Runyon then commented about the fourth bullet point on page 12 of the applicant's Stantec report. This refers to municipal plans. And as village president of the village of Chatsworth, President Mr. Runyon expressed that he did not believe that the village of Chatsworth had been contacted about this statement, so he questioned the value of this report. Here's a point that Mr. Runyon apparently misunderstood, and it's from our Exhibit 44, which is the Plan Consistency Report. Excuse me. Is the land use change consistent with municipal plans, if applicable? The proposed land use is consistent with the county's plan. No adjacent communities have conducted individual plans. Therefore, the project will be subject to jurisdiction under county land use policy. And then we get to something familiar to Dr. Capasso. Page 5. Despite what Mr. Shope made clear before this board on January 29th. Throughout the hearing, The public at times participated in the discussion, in part questioning how the RPC could make a decision when they had not reviewed all of the evidence. The public also provided comments offering additional information about the project. So you have a recommendation based on false information, on improper factors, and on public pressure. Your plan commission certainly wasn't alone historically the first 3 times. Because here's what the Springfield-Sangamon County Regional Planning Commission has to say. This is Pleasant Ridge Exhibit 57. The SSCRPC finds that while some living near wind farms may find the sound generated by such facilities to be an annoyance, and this annoyance may have certain effects that are related to negative opinions concerning wind energy facilities, there is no current reliable empirical or epidemiological evidence that the sounds generated have adverse health effects. This includes the effects reported as coming from low frequency and infrasound. And if you look at our comprehensive plan report, which is Pleasant Ridge Exhibit 44, will the land use change constitute a precedent of an incompatible use and be a detriment to adjacent property? That's one of the factors, that's one of the considerations in the comprehensive plan. The proposed project is compatible with the current agricultural zoning and will not affect the agricultural land use of adjoining properties. The presence of the wind turbines will not prevent participating landowners from running fully operational farms, as only the land occupied by the turbine footprints would be taken out of production. The turbine and access road footprints are extremely small when compared to the project area as a whole. Less than, remember we have 1% for Deer Run, less than 1/2 of 1%. There certainly is precedent in this county, as suggested in the comprehensive plan. Wind farms were found to be consistent with the comprehensive plan every single time the issue came up until now. Now let's look at the Natural Resource Inventory Report, which I thought I had here, but I don't miss it. This thing, from the Soil and Water Conservation District. Here's the introduction. This Natural Resource Information Report was prepared by the Livingston County Soil and Water Conservation District at the request of Invenergy. It's not required. It's not in your ordinance. But Invenergy did it anyway. Like the proposed agricultural impact mitigation agreement that we'd love to negotiate with you. An agreement that no other wind company has ever proposed. And yes, like the property value guarantee. Not because there will be any impact on property values, but because unlike the perspective of people like McCann and Rand and Illinois Windrush, your citizens are pawns in the political chess game. What else does that report from the Soil and Water Conservation District say that is consistent with the Plan Commission's prior recommendations and completely inconsistent with what they said now? Only a portion of the 58,300 acre project area will actually host wind power facilities. The land occupied by project facilities has been estimated to be less than 1/2 of 1% of the total participating project area, assuming 136 turbines and associated access roads are constructed. There's obviously a whole lot more in this report, and I'll cut my legs off if I'm reading more of it, so just one summary. It is anticipated that an agricultural impact mitigation agreement will be established between Invenergy and Livingston County to address construction standards and policies pertaining to topsoil replacement, repair of damaged drain tile, and prevention of soil erosion. Relevant specifications and best management practices from the USDA's Natural Resources Conservation Service and other sources are included in the appendix to this report for reference. Specific areas of concern are outlined below and further detailed in the individual site summaries and maps. In the majority of cases, the concerns identified in this report are easily mitigated by adherence to the recommended best management practices. In those cases where more complex issues have been identified, we recommend relocating or rerouting turbines and/or access roads in order to minimize the potential for damages. Throughout the survey process, Invenergy has actively sought input from the Livingston County Soil and Water Conservation District and has demonstrated a willingness to incorporate the findings of this report into their plans. And their members of the board, when combined with the evidence in this proceeding, I haven't put you to sleep yet, have I? That completely dispels any rational basis for your Plan Commission's recommendation. A recommendation that is completely contrary to every other recommendation that has been made. Is the proof that this facility will, in fact, be consistent with the comprehensive plan. Number 2, will not be detrimental to or endanger the public health, safety, morals, comfort, and general welfare. I'm not going to repeat everything I think we've covered. Number 3, is located in a zoning district where such use is permitted. Your wind ordinance specifically allows a wind farm as a special use in the ag district. 4, complies with the requirements set forth in the zoning district where it is to be located, etc. As I said earlier, I think the Patrick Engineering report has confirmed that for you. Number 5, will not be injurious to the use and enjoyment of other property in the immediate vicinity for uses already permitted, or substantially reduce the value of neighboring property. And again, I think I've covered that, but I won't reread what Bruce said. You know what Bruce said, and you know what McCann did. Number 6, will not impede orderly growth, development, and improvement of surrounding properties for those uses permitted in the zoning district. Mayor Gulliford of Forest certainly confirmed that, and it's also addressed in our comprehensive plan report, Exhibit 44. Will the land use change conflict with existing commitments or planned public improvements? There are no known conflicts with existing or planned public improvements or approved developments. The project land use is compliant with the county's zoning ordinance, as well as plan elements, such as the preservation of agricultural land use. And of course, on the contrary, as Professor Loomis and Mike Bruce pointed out, this project, like the other projects, will be an economic engine that will spur growth and improvement. 7, is provided or will be provided with adequate utilities, access roads, drainage, and necessary facilities. That's confirmed in the NRI report and in our project plan in this record, and it's also, again, summarized in the comprehensive plan report. Is the land use change located where the needed infrastructure services have been or can be provided? The project was designed to utilize existing infrastructure and the agricultural land use. Access roads to service the turbines and the collection system will be constructed by Pleasant Ridge. A 9-mile-long overhead transmission tie-in line to an existing substation will be constructed by Pleasant Ridge and represents new infrastructure. Number 8, is provided with ingress and egress so designed as to minimize traffic congestion in the public streets. Here again, the project plans, the testimony from Attorney Lenz on behalf of the Township Road Commissioners, and it's also again summarized in the comprehensive plan report. Will the land use change contribute to unsafe traffic patterns or undue congestion? And one thing that let's not forget, when Kevin Parsons spoke last week, you remember, Mr. Chairman, you asked him about consulting with the school district with respect to the traffic plan. He said, absolutely. Construction and operation of the project will require some temporary and permanent improvements to existing roadways. These improvements will be completed and enhanced by Pleasant Ridge. Roadway use and repair agreements will ensure that Pleasant Ridge repairs any damage to county or township roads as a result of public project construction. Traffic disruptions, which are a normal consequence of any major construction project, will be managed with appropriate barriers, markings, and flagging. Upon completion of project construction, there will be minimal project traffic associated with the routine maintenance of the turbines. No impacts to local traffic patterns or traveler safety are expected to occur. And so here we are, finally, after 7 months. At least for now. Thank you.
Thank you. 98 minutes.
How long?
98 minutes.
I told you I'm terrible at it.
maybe, all right. I've got 9:55. I think we're done for the evening. Tomorrow night, we're going to meet in Fairbury, back at the Walton Center. Are we still on 7:30? Do we want to do 7:30 or 8? 8. All right. 8 o'clock tomorrow night, Walton Center. All right.
Bedtime.
We're gonna, tomorrow night we'll hear closing statements. We'll do as best as we can. Probably a couple hours worth. Mr. Lucans will have the opportunity, and then I'll have this list, the list that is available online for all of you to look at. And we'll just start in alphabetical order and we'll work our way down. Pretty much, if you don't go when we call, we're probably gonna go through this one time, unless this goes over to the next night. But we'll get through it once, and so be ready. Your time limit is 2 minutes. All right, so we're all clear on that. Just on that.
If the two attorneys can give me their updated list of exhibits based on what happened tonight.
Yes, they'll have that tomorrow from us. And we'll delete 63. We'll also delete 63 as you requested.
Sure.
And I'll have Mark the list of exhibits as well.
Okay. Well, I actually changed my mind on that. Probably the best way to do it.
Okay.
Okay, so just update the list tomorrow and we'll figure out what we're going to do to get them record.
You know what, I apologize, Mike, I didn't hear you, I didn't.
We had talked about marking the actual list as an exhibit.
All right. With that, I need a motion to recess.
I'll make that motion.
This motion. Did I get a second? Houston seconds. All in favor? Aye. Opposed?